Randy, thank you. This matter, for a while I've chosen not to talk about it because, it's before the courts and I've left it. But yesterday, the issue came up again because of the hearing. At the heart of the dual suit by Richard Delasky and Amanda Odoy are two articles of the Constitution, 106 and 108. Now, 106 is the heart of the injunction hearing that's been ongoing for about 2 months or 3 months now. We're expecting ruling on the 17th. 108 is at the heart of the substantive case that we haven't gone into. Now, the Attorney General is actually a respondent in the case. Because the respondents are the Speaker of Parliament and the Attorney General. Let me be clear that 106 of the Constitution is titled, the heading of 106, Mode of Exercising Legislative Power. So Randy, 106 basically talks about how Parliament can exercise its powers as the legislative arm of government. And it says, this is very interesting to read, 106.1. The power of Parliament to make laws shall be exercised by bills passed by Parliament and critically and assented to by the President. So it means that the exercise of Parliament's legislative power is not just in passing the bill, but in getting the assent by the President. That is 106.1. I read again. The power of Parliament to make laws shall be exercised by bills passed by Parliament and assented to by the President. So that is the mode of exercising Parliament's legislative power. Then it proceeds to then break it down in 2 all the way to 6. How the committees will sit, what they can sit on, and all of that. Now, it then proceeds, because it had in 106.1 stated that Parliament's legislative power is not exercised either or, but end. The word used there is end, meaning both the passage of the bill and the assent by the President is what shows the executive power. It then gives you the scenarios where the President may seek as the executive to interfere in the exercise of legislative power. That is where the President decides not to assent to a bill that has been transmitted to him. So it then lets you know that until you have the assent of the President to a bill, the process is not completed. Because it says that when you pass the bill, send it to the President in 106.7, where a bill is passed by Parliament, where a bill passed by Parliament is presented to the President for assent, he shall signify within 7 days after the presentation to the Speaker that he assents to the bill or that he refuses to assent to the bill, unless the bill has been referred by the President to the Council of State under Article 90 of this Constitution. So it then means that the assent of the President is what then ends the legislative exercise of legislative power. The President can choose not to assent. It then means that Parliament's legislative power has not been exercised completely. Because then it then says that in the case where the President in 106.8, where the President refuses to assent to the bill, he shall within 14 days after his refusal, state in a memo to the Speaker any specific provision. So he can't just carte blanche say, I refuse. He must then refuse with a memo to the Speaker, stating the basis of which for his refusal. And it can't just be something extraneous to the bill. He must state what provisions of the bill he disagrees with. And then it doesn't end there. It says, any specific provisions of the bill which in his opinion should be reconsidered by Parliament, including his recommendations for amendment. So it then means that when the President says, I don't assent to this bill, or I'm refusing to assent, within 14 days he must do a memo to the Speaker stating what is wrong with the bill.
So the point that you make is that from what you read,
yes,
the 6, the 7, and the 8.
yes,
Parliament's legislative function cannot be complete unless there's a presidential assent.
Yes.
Because in the event that the president refuses to assent, and he gives reasons, and he has issues with particular provisions,
yes,
Parliament will have to continue its work again.
That is captured in 1069.
Yes.
Parliament shall reconsider a bill, taking into account the comments made by the president or the Council of State.
So what it means is that if you read the entirety of 106,
yes,
until there's a presidential assent, the legislative work of Parliament is not complete.
It's not complete because the president, either on his own or upon the advice of the Council of State, can actually ask Parliament to reconsider portions of the bill.
It is only when he has assented
that it's done.
Okay.
Then Parliament has no further work.
Right.
But until there is an assent, there is always room that second consideration, there will be another second consideration. And even with this bill, we did second consideration 3 times. We finished second consideration. The Speaker was about to go to third reading. And I came with my colleagues to ask for a second consideration, a second consideration. And we did it a third time. You understand me? So it's always possible to go back. And that's why, for me, I side on all fours with the Right Honorable Speaker. Because the Right Honorable Speaker is not speaking his mind. He's protecting the integrity of Parliament's constitutional powers. And that's why many of us hold the view that in the first place, the Supreme Court, with alacrity, ought to dismiss this case and not even entertain it, because we have not completed our work. The Supreme Court must bear in mind, the Judiciary, the Chief Justice, must bear in mind that she is stopped by the Constitution from entering into the arena of Parliament. And Bobo rightly stated it, that the role of the Judiciary is to interpret legislation that Parliament has passed or interpret the Constitution. Now, it's a different thing if the individuals have gone to court asking the court to interpret Article 106. That's a different matter. But they have gone to court asking the court to injunct the Speaker from carrying out a constitutional mandate. And you see, Randy, Roxin, Nelson, Eche Dafiamepo carried out a similar action where he sought to get the courts to injunct Mr. Speaker, from having the House consider the nominations, the last nominations the president made, because in his view, people like Bobo, who moved from one position to another ministry, the president revoked the appointment. And so once he was renominating them, they ought to appear before the Appointments Committee of Parliament again. What was the determination by the Supreme Court in that matter? The Supreme Court ruled and said that they could not injunct or interfere in the workings of a constitutional body carrying out its constitutional mandated functions, and that Parliament is mandated by the Constitution to hear, vet, and approve nominees of His Excellency the President. Parliament, by the same Constitution, is mandated to transmit the work of Parliament, bills that have been passed by the House, to the President. But for me, I think that where the Speaker stands is supported by the Constitution. Because if today the President has not received a bill from Parliament, how do you say we've completed our job? How is the Supreme Court going to interpret something that is not law? And that's why even yesterday, in a similar matter, when our
the Supreme Court is being asked to interpret perhaps a position that, and I hope I'm not being unfair to Ejapa, a position that Ejapa gives me the impression he holds, that the legislative work of Parliament is done to the extent that you have approved.
Well, that's
you don't get what I'm saying.
I do. I agree.
The position of the Speaker, as I read, and which is what the Speaker is saying, is that until the presidential assent is obtained, the legislative work is not done. Because if the president refuses to accept and he gives his reasons as the Constitution says he should do, and even has issues with portions
of the bill.
Parliament is expected to work again on those things. So it is only the accent by the president which ends the process.
And in fact, so 1061 is clear on it.
So therefore, you have a situation where, and I hope I'm correct or I'm not wrong, you have a situation where there are some citizens of the Republic who believe that the legislative work of Parliament is done. And the transmission, as Japa is saying, is administrative, is not part of their work. And so it is up to the Supreme Court to now say that, hey, the legislative work of Parliament, as we understand per 106(1) and all that, ends with the presidential accent. So the transmission is still part of that legislative function. So you cannot injunct them.
Yes, and I think that eventually is what the Supreme Court will have to determine.
Thank you.
But the point I'm making is that we have precedents from the Supreme Court.
Yes.
With the Roxanne Dafiameko case.
Yes.
Where they said we cannot injunct a constitutional body from carrying out its constitutional function. It's the constitutional function of Parliament to carry out legislative exercises. Yes.
In fact, the transmission is part of it.
It's part of it.
In fact, that is why in the suit, the issue of the transmission is the Speaker who's being sued.
Yes, not Parliament and not the clerk.
Yeah.
It's not Parliament as a body. It is not the clerk. It is the Speaker himself. You understand me? And so it's important that, and I've restricted myself to the 106 part because the fiscal impact analysis document now begins to speak to the substantive case as to
we'll get there. We'll get there later.
Because 108 says that the person presiding. So we'll get into all of that. But I will wait to see how the Supreme Court is going to rule this case, given all the precedents that they have set. You know, not just in the Ejapa case, but even with Amanda Odoi, where during the second consideration stage, she went to get an injunction to injunct Parliament from carrying out.
But it wasn't granted.
That's what I'm saying. That Randy, I'm saying that I'm giving you the precedents that has been set on by the Supreme Court in the last 1 year on the functions of Parliament.
Right.
I'm saying that Roxanne's case, they said they couldn't injunct Parliament. In Amanda Odoi, the same Amanda Odoi, when she went to Parliament, to the Supreme Court, whilst we're in the second consideration stage, they said Parliament is carrying out its legislative function. So they threw it out. I'm saying that, again, we will come to the heart of it, is the transmittal and approval or assent by the president or otherwise. Does it form the basis of Parliament's exercise of its legislative function? I hold the view that 1061 settles the matter. But we'll wait to hear what the Supreme Court will say.
Okay.